Good morning, everyone. We're going to proceed today out of order. The first matter will be Matthew, People versus Matthew, number 46 of 2024. Proceed.
Good morning, Justices, and may it please the Court. My name is Sean Bailey, Assistant Attorney General, and I represent the appellant, the people of the Virgin Islands. I would please request 3 minutes for rebuttal.
Very well.
The Superior Court's opinion granting appellee's motion to suppress, like appellee's argument on appeal, is premised on the idea that the search warrant in this case was unsupported by probable cause because the Virgin Island Police Department's affidavit in support of the warrant did not state either that appellee owned a cell phone or that appellee was seen using a cell phone during the shooting. However, once the VIPD were lawfully present inside Cumberbatch's apartment to execute a valid and uncontested warrant to search for firearms and ammunition, and saw 2 smartphones sitting in plain view, there was more than a fair probability, and therefore probable cause, to believe that the phones would confirm the location of the suspects at the time of the murder. And therefore, the Superior Court's order granting the motion to suppress should be reversed. Upon entering the apartment and observing the phones in plain view, the officers knew the following facts. First, surveillance footage from the crime scene showed 2 individuals arriving together at the victim's home, exiting the vehicle, and immediately firing shots at the victim. The video also appeared to show those 2 individuals arriving at the scene of the crime together and leaving together in a distinctive white Acura with chrome rims and a sticker on the rear passenger glass. A white Acura of the same description was known by officers at VIPD to be operated by Cumberbatch, who resided at number 2 Betsy's Jewel. Upon going to Betsy's Jewel, the owner of number 2 informed VIPD that Cumberbatch was a tenant of apartment A and is, quote, sometimes there with a male. Less than 12 hours after the shooting, a white Acura of the same description was found in the driveway of Cumberbatch's residence. Also less than 12 hours after the shooting, Cumberbatch and appellee Matthew, who matched the descriptions of the 2 individuals seen in the surveillance video, were found inside Cumberbatch's apartment. At the same time, 2 cell phones were found sitting in plain view in areas of the apartment that were easily and readily accessible to the suspects that they found inside. Those cell phones were notably smartphones of the type that regularly and automatically track and store location data, in this case, iPhones.
How did the officers get into the apartment?
Pursuant to a valid warrant and an unchallenged warrant, a telephonic warrant, to search for firearms and ammunition. At a minimum, it is valid and uncontested as to that.
So why don't you tell us what was in the warrant?
Certainly, Your Honor. The warrant was applied for and granted telephonically on March 2nd, 2021, but later reduced to writing on March 5th. What I just read to you, that summary of the facts known to the officers, is taken pretty much verbatim from the affidavit in support of the warrant, also submitted and reduced to writing on March 5th. And the warrant it eventually concludes that, oh, there it is, sorry. The warrant says to search for the following items: cell phones, any firearms, ammunition, firearm cleaning kit, gun manuals, firearm holster, gun firearm paraphernalia, any documents relevant to possession of said firearms and/or ammunition, clothing, and any other firearm-related items.
Well, did the affidavit supporting the warrant, did that mention the cell phones?
The affidavit submitted in support of the warrant did not, once it was reduced to writing, it did not specifically request to, it didn't list the items that were requested to be searched for. However,
Of course, and let me tell you why. I think that we're going too far afoot with this. Let me clarify something. You got the 2 volumes before you?
yes, Your Honor.
Yeah, turn to page 1 of volume 1.
Sorry, which page?
Page 1 of volume 1.
Yes, sir.
And page 1 says that you are, the sole issue before this court today in this interlocutory appeal has to do with the cell phone, Sharif's cell phone. Am I correct?
Yes, you're right.
Yes,
The
okay,
motion to
good.
suppress was granted to suppress evidence obtained from the cell
Now go
phones.
to page 242 of volume 2, where the sergeant, Sergeant Ashi Julius, is being cross-examined by Mr. Moorhead. And let me know when you get it and follow me, because this is crucial to me, and I don't want us to go all over the place with it. Let me know when you have 242 before you.
I have it, Your Honor.
Okay, good. Look at line 12. Question: did you see, and this is Attorney Moorhead's, the co-defendant's lawyer, talking to Ms. Julius, who is on the witness stand. He said, did you see at any time, did you see the male and the female individual communicating with each other? I don't remember. Hogwash. There is no audio in this video, is there? There is none. All right. Go down to number 25, line 25. At any time, did you see Mrs. Komobash using the cell phone? And then he said, not. And then he said, question, in the video? He said, in the video, no. At any time, did you see the male individual, which is Mr. Sharif, using the cell phone? Not in the video. At any time, did you see Mrs. Komobash using an electronic tablet? Not in the video. Do you have any evidence, or did you know Mrs. Komobash before this incident? No. So you don't know whether or not she has a cell phone? No. Did you see any cell phone in the video? No. Do you communicate this to the magistrate? And then she says, regarding the cell phone, do you remember the communication that I observed any of them using the cell phone? I did not.
Yes, Your Honor.
Oh,
And
hold on. That's because you didn't see them communicating? I did not. You didn't see anybody texting anybody? No. Nothing further. In other words, there is absolutely no evidence, whether on the video or the detective, of seeing, when she utilized the video that was on the outside, on a building, a neighbor's building or something. She never saw any one of them, either this defendant, Sharif, or Ms. Komobash, using a cell phone.
That is correct.
They never see a cell phone. Nothing at all. No evidence of a communication by a cell phone.
that's correct,
Then-
Your Honor. And
then-
that was the focus
then-
of the Superior Court
Then,
and of the
hold on
appellee.
one second. Then why in God's name do you want to go into somebody's house and pick up a cell phone when in fact you don't put it in your affidavit for the warrant, and you would testify under oath that she knows absolutely nothing about a cell phone?
Your Honor, like I was saying, and as I opened with, That was the focus of the Superior Court and the focus of appellee, but under the rapidly developing law of the search and seizure of cell phones around the country, that focus is misplaced. Cell phones are not only relevant to the extent that they are used to communicate about the commission of a crime, but smartphones in particular are known. Smartphones in particular are known to carry the location data.
Hold on. Where is any evidence, any nexus that any one of these two defendants utilize a cell phone in communicating involving this crime?
Your Honor, it's not necessary for the police to have observed a cell phone being used in commission of a crime.
No. Listen to what I'm saying. Is there a nexus between the crime scene, and the utilization of a cell phone?
Your Honor, whether or not that would be sufficient to support the issuance of a warrant in the first instance, upon entering the apartment on the warrant to search for guns and ammunitions and seeing the cell phones in plain view, readily and easily accessible.
Since when does a cell phone automatically becomes illegal to have a cell phone in your house, or it automatically becomes an implement or something utilized in a crime?
It certainly does not, Your Honor. But the question is not, is it illegal? The question is whether there is probable cause, that is, a fair probability to believe that evidence relevant to the investigation of a crime may be found on that cell phone. And courts increasingly around the nation recognize, the Supreme Court itself recognized.
Are you saying, sir, that because somebody have a cell phone with all their private data on it, that if in fact that a crime has been committed and you don't know anything about the alleged suspect, you have no evidence that the phone was utilized, unlike when certain people are transacting drug deals, you know, they're communicating by cell phone and whatnot. Nothing like that is here.
No, Your Honor. I'm saying that the Virgin Islands should follow the lead of courts on the cutting edge of this rapidly developing.
I need to know what is the law now.
The law now is that upon entering, being somewhere where the police have a right to be and seeing an object in plain view, they are entitled to seize it if the
has to be connected to a crime.
The incriminating nature needs to be immediately apparent.
Are you telling me that a cell phone is has an incriminating nature because it's utilized for people to run their business, do business transaction?
It's not me telling you, Your Honor. I'll quote the Court of Appeals of California. It's a matter of indisputable common knowledge that most people carry cell phones virtually all the time. And courts may take judicial notice of, quote, facts and propositions that are of such common knowledge, and they cannot reasonably be subject of dispute. The United States Supreme Court observed that individuals, quote, compulsively carry cell phones with them all the time. While individuals regularly leave their vehicles, they compulsively carry cell phones with them all the time. Cell phones are now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. Other courts have followed suit in recognizing that nearly everyone carries a cell phone.
That does not answer my question. In order to see something in plain view, it has to be a nexus between the crime committed and that particular object.
Yes, Your Honor.
And you cannot point to any part in Volume 1 or Volume 2 of this record where that cell phone that was in her house, that it has a right to be.
Absolutely, Your Honor.
Was somehow has an intrinsic value as a weapon to be utilized in a murder case?
Courts around the country have inferred, I'll quote from the Pennsylvania Superior Court, it was a reasonable inference that if the phone was in appellant's possession when he was arrested in his vehicle, only hours after the shooting, it was more probable than not that it was also in his possession at the time the murder occurred, and could therefore confirm his location at that time, or contain messages.
Which case was that? Which case was that?
That's Commonwealth versus Thomas. Commonwealth versus Thomas, Your Honor. 2020 PA Superior Court, unpublished Lexus 2364 is the citation I have. But there are others, Your Honor.
Did you look at the Pennsylvania Supreme Court case in Johnson, Commonwealth v. Johnson.
I don't have that in front of me, Your Honor, but I researched the matter extensively.
Mr. Cabral, you had a question?
Well, my question went to stand-in. Your argument is that Mr. Matthew had no stand-in to challenge the seizure of his phone in Ms. Cumberbatch's house. But aren't cell phones personal to the owner? I mean, and the right to privacy of all the data, aren't those personal to the owner?
To the extent
Of the
I
cell
understand,
phone?
so to the extent I'm understanding your question correctly, Your Honor, yes, individuals have a right to an expectation of privacy in the contents of their cell phones. The Supreme Court established that in Riley, the landmark case.
So my question then is, if I go to visit person X and I walk into that person's house, do I lose my right, the right to privacy in my cell phone? To
No,
all the
Your
data
Honor.
that is in my cell phone?
No, Your Honor.
I'm trying to understand your stand-in argument.
That argument, we're not making that argument in this case. That argument was
Okay.
made in the
Cumberbatch?
companion case, Cumberbatch, yes. And that's, on the particular facts of these cases, there was no claim of ownership of cell phones at the time the police entered and saw the phone and properly seized them in accordance with the plain view doctrine as
Was the plain view doctrine discussed in the trial court?
not to my knowledge, Your Honor.
So why should you be allowed to raise it here if you never raised it in the trial court?
Well,
That court never had a chance to analyze the plain view, so why should we?
for two reasons, Your Honor. First, I would say that the waiver of waiver doctrine applies here. Appellee did not argue that the issue was waived anywhere in his brief. In fact, Appellee did not address the plain view argument at all, but continued in the section that purports to address plain view, simply discussed more on the good faith exception. But more importantly, Your Honor, because the stakes here, the interests of the people, of the judicial system, are incredibly high in a first-degree murder case, such as the one presently before the
Well,
court.
with-
Whether it's a first-degree murder case or whatever, you have to have probable cause. And nowhere in her testimony does the detective said that she knew anything at all about a telephone, about a cell phone. There's nothing at all in this record where when the two defendants were on the outside, anybody saw them with a cell phone or communicating via cell phone. So
Well-
you maybe you had probable cause to search for the weapon, the gun in the house, but the cell phone?
No, Your Honor, but as the Eighth Circuit Court noted in U.S. v. James, even if nobody knew for sure whether the suspect actually possessed a cell phone, the judges were not required to check their common sense at the door and ignore the fact that most people compulsively carry cell phones with them all the
But in
time.
those cases,
what?
I'm dovetailing on to Justice Swan's comments. In those cases, does not the detective or police officer in his or her warrant, do they not include a statement, a general statement that indicates, I'm paraphrasing, based on my experience as a law enforcement officer, I know that cell phones are commonly used, are owned by just about everybody, and they're commonly used in committing crimes. And is that kind of paragraph in this affidavit, in the affidavit supporting these cases?
They do, affidavits do generally contain those sorts of statements about common knowledge regarding cell phone use, and perhaps that is the best practice. However, that's not dispositive of this case, and the Superior Court's order should still be reversed for two reasons. The first is warrants are to be judged not on what they lack, but on what they contain, and there's good law to the effect that if something like that is omitted from an affidavit, inferences known generally to police officers and to judges, things like that, it's on the magistrate to request that they be added to the affidavit. Those sorts of situations are specifically covered by the good faith exception. But the second reason, and more important reason, which is the emphasis in this case, is that even to the extent that this court concludes that there was not sufficient probable cause or the affidavit was insufficient to justify the issuance of a warrant, the warrant as to guns and ammunition is unchallenged, and once officers were in that apartment pursuant to that valid and unchallenged warrant and saw two smartphones sitting in plain view only hours after the shooting, they had probable cause based on those general understandings and about cell phone use and common knowledge regarding how people use cell phones.
Are you arguing that in every single case there is probable cause to search for a cell phone?
No, Your Honor. I'm limiting my
Well, that's
argument
what
to the facts of this case. But I will note that in Riley versus California, the Supreme Court affirmed the general practice around the country, which is to seize cell phones incident to arrest in nearly all cases in which any evidence could conceivably be found on a cell phone.
Yeah, but that's totally different.
That is a cell phone incident or an arrest. But we are talking here where there's absolutely nothing at all, nothing on this record, and that detectives have admitted that she did not know of any one of them having a cell phone. Nobody was utilizing a cell phone, no communication by a cell phone. You get a warrant to search for guns in the house, you go inside and say, ha, that cell phone, I think I better grab it because it just might have evidence.
Respectfully, Your Honor.
Well, what you are looking at is a general warrant. And you know what the Superior Court judge said about general warrant.
Again, Your Honor, even to the extent that...
Thank you.
Certainly.
We've gone over 8+ minutes, so you still have your 3 minutes on rebuttal.
Thank you, Justices.
Okay.
Good morning.
You can bring it down right
Okay.
in front of you.
Short people. Good morning. Anthony Kitcher on behalf of the appellee, Sheriff Matthew. There was no error, no abuse of discretion by the Superior Court when it suppressed the cell phone evidence in its ruling. The telephonic warrant that was issued by Judge Gallivan was a general warrant. This is quoting the Superior Court judge. And is therefore presumptively unreasonable as it did not meet the Fourth Amendment's ambiguous requirement that a warrant particularly describe the person or things to be seized.
The place to be searched with
exactly.
particularity.
Exactly.
The thing to be seized, so for all intents and purposes, the government can't rely on the search warrant of the home, so now they come up with plain view. But isn't it true that in plain view, when you walk in and you see plain view, whatever you see in plain view has to have some meaningful nexus towards the crime and the search that you are conducting?
Exactly, Justice Swan. There was no nexus. There was no nexus between the cell phone and the crime that happened in the estate Carlton. There were, in the affidavit, the application for search warrant that was put into writing by Judge Gallivan, there's no mention of a cell phone being used. There's no mention that from Detective Jules, that in her years of experience, perpetrators might have used a cell phone. My cell phone might have evidence, so therefore we want to search the cell phone. Judge Gallivan made 11 points. Nowhere there's a mention of a cell phone or a smartphone or electronic device. They said that there were two individuals, one male and one female. There was no verification or confirmation that the male individual was my client, Appellee Sharif. It will say it was a tall individual. They couldn't make out that. And with the stand at the hearing, Detective Jules, she couldn't confirm that it was Matthew. She didn't see Matthew with a cell phone, as Justice Swan, when you were grilling my opponent earlier. there was no mention in the hearing that from Detective Joel stating that a cell phone was used. There's no mention of a cell phone. Therefore, when the police entered,
And there was many times when there's a charge of conspiracy, you would have the conspirators communicating by cell phone. In many of the drug cases that I have looked at, many times when you have a big drug deal coming down, there's a lot of communication going on by cell phone. But we don't have that here.
exactly, Judge.
We don't even have here where a cell phone was at the crime scene or utilized in the commission of the crime of murder.
Exactly.
And they go to somebody's house searching for guns, which, you know, you figure that, because I noticed that there's no challenge to that. But, and all of a sudden you see a cell phone over there. He said, I might be able to find some evidence on that. But in order to do that, just looking at a cell phone is not intrinsically a weapon, and it's not utilized by the millions of people using telephone. They communicate, they do business on the phone, but it's not a weapon as such.
Exactly, Justice.
And this thing about plain view, because something in plain view, then you could go in anybody's house and look around and say, I think that object over there could or might or may have been utilized in this murder. So under the plain view, I'm entitled to it. And it has to have some basis for saying that that's the kind of thing that you would find. Now, I can see if you go in and you see a knife, a gun or something, but a cell phone?
Exactly.
Attorney Kitcher, is it correct that a whole lot of drugs was observed in plain view in the bedroom?
They found some marijuana, but that's
It was packaged in such a way that it was clear for distribution. It wasn't for personal use, correct?
it was. Well, based on the evidence that I have received, it's not an evidence in this matter. It wasn't for distribution.
But based on the description of the amount and the packaging, isn't that clear that it was for distribution?
No, Judge. I would disagree with that.
Well, you would agree that having found a large amount of drugs in plain view, that they could seize those, correct?
That the drugs
Yes.
is one thing, but
Now, I'm
not.
asking you, could they seize the drugs?
They could seize the drugs, but how?
Okay, and if you have a cell phone in near proximity in the same bedroom with those drugs, couldn't they also seize the cell phone?
No, Judge.
Since it is generally accepted that cell phones are used in drug trafficking?
But Judge, this wasn't a drug trafficking case.
But just, I mean, you might say it was not, but based on the description of the drugs that were found, the way they were packaged, a reasonable officer could assume that they were for distribution, correct?
Judge, I will respectfully disagree with that assessment. Judge, Justice Hodge, drugs, if they did find an unreasonable amount of drugs, but they did not, it would have been more.
But you agree that just about all the courts agree that cell phones are generally used with drug trafficking, distribution. You know, people call to place their orders. It's used in connection with drug trafficking, and that's what basically all of the courts have said, correct?
But they have to show a connection, a nexus between the conspiracy, the drug trafficking, and the cell phone. Was the cell phone used to schedule a drop off or a pickup or a sale? No. In this matter, it's about a murder. There was no mention of a cell phone.
Well, with regard to the data that is on a cell phone, the cell phones also have location data, do they not?
Correct.
That can be very valuable in any crime that involves, well, like in this case, there was a murder. So if there was a cell phone utilized, wouldn't that cell phone have location data showing the individuals to be at the Estate Carlton area at or near the time of the murder?
But a cell phone also has some personal information, vital information about that individual. Is a part of that person, the body. Therefore, you need to have in the warrant or the application.
Well, let's say the
for
cell phones were in the car. Let's say that they were in the car. Wouldn't that location information be on those cell phones?
What do you mean, if it was found in the car or?
No, I'm not saying whether they were found in the car. You're saying, as I understand your argument, is the argument is that there was no mention of any cell phones, no one saw any cell phones or the use of any cell phone on the video. And I'm saying, well, I'm asking whether the cell phones, could the cell phones not have been on their persons or in the vehicle that, in the Acura TL?
Judge,
Even if they weren't used, if it wasn't even turned on, wouldn't those cell phones show a location based on?
that would be beyond my. However, Judge, with a cell phone, I have a cell phone right now. My cell phone shows that I'm in sub-base. But however, what if I told somebody I was someplace else? My cell phone have on my financial information, my personal emails, my
Also have your location.
my location. However, I have.
If a murder was committed while you were at this location, the cell phone would have that as well.
However, I have expectation of privacy in my cell phone. The search warrant should have said, I would like first the reason why the cell phone is connected to the crime, then to what information they're looking for, whether it's GPS or we call the location monitor for a specific time,
but-
not just over. Sorry, Judge.
Yes. Would not the government have to obtain a second warrant to retrieve the data from those cell phones?
As Detective Jules has been touted as a seasoned officer, she should have known that the warrant or the application for the warrant that was issued on March 2nd, 2021 was invalid. She's the one, sorry, Detective Jules is the one that provided information to Judge Gallivan. Judge Gallivan took down notes and she put it into writing to conform with Rule 4-1. There's nowhere in that memorandum for search warrant mention of a cell phone or electronic device.
But not only that, but you really didn't need their cell phone to determine whether or not these defendants were at this place, because you have all the videos. You got a video evidence, and that was utilized in terms of securing the warrants. And in terms of the video capture both defendants in the area. As a matter of fact, the video capture when allegedly Komobash with the limp went up to look in to make sure that Mr. Abraham was in the house, and then she went back and then she spoke with this gentleman who went over, raised his hand, purportedly had a firearm, and do the shooting. So all this, nothing in this crime at all, in terms of warrant, in terms of knowing whether they were at the crime scene or not, they either were there or they were not there, and the video have already speaks eloquently as to their whereabouts, the car that was utilized, you know.
Just
So This
So
thing
for
about,
Matthew, did the video, was they able to identify Matthew from the video?
No, Judge.
So therefore, the cell phone would certainly corroborate or at least identify him
And,
as being in that location.
But Judge, the warrant was invalid. And just in reference to the video in which it said they saw a man, it wasn't identified that as being as Mr. Matthew. In addition, the landlord for Mr. Cumberbatch said that she did sometimes with a man, with a male. She didn't say she was there with Mr. Matthew. So therefore, it doesn't have to mean that Mr. Matthew was that male individual that visited Ms. Cumberbatch. She could have other male individuals visiting. He was just there. So therefore, he had an expectation of privacy in his cell phone. He was a visitor of Ms. Cumberbatch.
Okay, to get back to the cell phone in the bedroom, which was Mr. Matthews' cell phone, the two in the living room was Ms. Cumberbatch's. Now, the appellant in this case, the government, the people, claims that although it was not presented, the plain view argument was not presented to the Superior Court, that they raised it in their brief. You did not, well, not you, but at least whoever wrote the brief did not address that with any significance. It just perfunctorily just say that it doesn't apply. And that you therefore waived in a waiver that the government made. And why shouldn't we accept that you did not basically object, and therefore you waived it, and therefore we should be able to consider that plain view argument as to the cell phone and proximity to the contraband, the drugs that were in the bedroom, and why shouldn't we consider that there was enough probable cause that the cell phone could have been used in connection with the drug trafficking and sought to seize it on that basis?
Justice, as I repeat, there was no probable cause for the search, to seize and search the cell phone. In reference to the plain view, the argument does not stand in that it has been the contention of the appellee that the government, the VIPD, didn't have the authorization to enter, to search or to retrieve the cell phone because the warrant was deficient. There was a general warrant that should have been tasseled from the get-go. And what happened is that the government is trying to go back and correct the issues. The government should be held accountable for the action. This warrant that was submitted to Judge Gallivan, and the second was not, and is not a valid warrant. Someone with the so-called experience of Detective Jules should have.
Well, let me ask you this. Was there an amended information file in this case? Because I don't see one.
Judge,
It was just one information file.
correct.
All right. And,
Thank you.
And of all the crimes that are charged, none of them have absolutely anything to do with drugs.
Correct, Judge.
None whatsoever. Even to the one they call the conspiracy, which is the last count, that's a conspiracy to commit murder and assault in the third degree and everything. So all along, if the only information is the one that was originally filed, it charged murder in the first degree, assault third degree, unauthorized possession of a firearm, and the discharging of a firearm, and possession of ammunition, and conspiracy in connection with the murder. But nowhere in the information is there anything remotely charging anything to do with drugs or with the sale of drugs or the distribution of drugs. Nothing whatsoever.
That's correct, Justice.
Okay, thank you.
All right, thanks.
First off, did you file an amended information?
I do not believe an amended information was filed in this case, Your Honor.
So-
But I'd like to just begin by saying there is certainly no dispute that appellee has an expectation of privacy in their cell phone. As I was alluding to earlier, the Supreme Court reaffirmed that in the landmark Riley decision. Appellee continues to emphasize, as the Superior Court did, as appellee did in their brief, that there's no mention of cell phones at all. But that's not dispositive in this case. Appellee does not engage with the abundant, emergent case law in the rapidly developing area of probable cause as it relates to cell phones, particularly probable cause to seize and eventually search a phone for location data, which, as the court was alluding to in its questioning, contains location data, which is very valuable in the investigation and potentially prosecution.
Information, you must have possession of the cell phone. Am I correct? In other words, you can't leave your cell phone at home and be in Market Square and involved in a murder in Market Square and your cell phone isn't there. So that data as to your whereabouts on your personal cell phone has absolutely nothing to do with the case.
I would respectfully disagree, Your Honor, and courts around the country have disagreed, noting that that is simply not how people who own cell phones use them. People keep cell phones with them all the time. It's a matter of statistical fact and also a matter of judicially recognized common sense at this point in courts all over the country. That location data, as Justice
But
Cabret...
you understand that we are dealing with the case that was presented below under suppression and the court's ruling and, you know, the evidence that was submitted to the judge to issue that telephonic warrant, because that's really the bulk of the issue. And you are bringing in all subsequent things, matters that court rules, and do we need to really get into all of that to decide these particular facts?
Your Honor, I don't think the court needs to get into all of that. It's our position that the affidavit did demonstrate sufficient probable cause to support the issuance of the warrant, and that even if it didn't, it was covered by the good faith exception to the warrant requirement. Both the probable cause requirement and the good faith exception are not based on technicalities. It's common sense, everyday information known to judges and police officers, including all of the facts and understandings about cell phone use in the modern world that the Supreme Court and other courts have discussed that I was reading about earlier. But to the extent that this court
All I know
determines
is
that there was...
Under your scenario, on this broad spectrum, out goes the Fourth Amendment having anything to do with a person's privacy, private papers, private everything, simply because they have a cell phone and people customary walk around with their cell phone. Don't you need something more than just that when you're going into somebody's private papers?
You do, Your Honor.
The U.S. Constitution
You
use
do. You
private
need
property, private papers.
You need probable cause, which is a fair probability based on common sense conclusions about ordinary human behavior of the type noted by the courts whose cases I read from earlier. And just to finish responding to Justice
let me
Hodge.
say this. Is it more probable than not that a crime has been committed in this case? Yes. Is there more probable than not that evidence of that crime will be found on the cell phone when we don't even know if they...
Absolutely, Your Honor.
If they even had a cell phone with them at the time they allegedly... I should be very careful because that case hasn't been tried yet.
According to courts around the country that are on the front line of this developing area of the law and the people's position in its brief, the answer to that is yes, there is absolutely probable cause. And just to briefly conclude in response to Justice Hodges' last question, if I may, to the extent, as I said, the people respectfully submit and firmly believe that there was probable cause in this case. that even to the extent there wasn't, it was covered by the good faith exception to the warrant requirement.
Hold
But
on, attorney. Are you saying that you don't have to make out probable cause in the affidavit when you are attempting to get an arrest warrant or search warrant?
absolutely not, Your Honor. Probable cause is the fundamental requirement for a search implicating the Fourth Amendment. But there was probable cause in this case, taking the facts stated in the affidavit, taken together with reasonable inferences drawn from them based on, as I said, common sense conclusions about ordinary human behavior, which have always been the basis of the probable cause inquiry, which, as the Supreme Court has said, is, quote, not a high bar.
Under
Okay,
your
thank
scenario,
you.
anybody could be arrested and charged with a crime. We
Thank
gotta be
you.
very careful
Thank you,
about
Justice.
that.
The matter will be submitted.